Good morning, Bob.
Good morning, Jack.
Today we're going to talk about the TikTok ban, which is not really a ban on TikTok, but rather a ban on the internet service providers and related companies through which TikTok runs. I and others have written a lot about the illegality of the Trump administration's blanket refusal to enforce the law. You wrote a piece earlier this week, yesterday, that expanded the lens to look at the companies who are violating the law. And so, why don't you tell us what you said, and we'll have a conversation about it.
Certainly, the attention has been largely paid to what Trump did in his executive order and then the follow-up letters from Attorney General Bondi purporting to confer immunity on the companies for violating the act and absolving them of any liability for the period of time these executive orders have been in effect. They've been extended multiple times. There's no indication that the administration does intend to enforce the statute. And there are no signals to the administration, say, from the Congress and from allies of the president and the Congress, the majority in the Senate, that they're going to force his hand in any way, that they're going to insist on compliance. I wanted to expand the lens to talk a little bit more about something that has received less attention, and that is the response of the companies. The companies have decided essentially to accept the devil's bargain. So they are also disregarding the statute. They're disregarding the statute purportedly in reliance on the executive order and maybe even more to the point on the Bondi letters that assure them that they will not be deemed to have violated the act, nor to be in the future violating the act for as long as these non-enforcement orders are in effect. And I wanted in this piece to just explore what it means for some of these companies, all of these companies, some of whom are the most dominant companies or among the most dominant companies in the American economy, play such an outsized role in our society, to, in effect, hand in hand with the president, completely disregard a law that they understand perfectly well as being illegally suspended in enforcement, not being enforced. And I look a little bit at the statements they've made about their compliance policies and their business ethics codes. Their actions now are not consistent with the commitments they've made in those ethics codes. I take ethics seriously. It's a point I keep on coming back to with varying degrees of success with different audiences. But they are not doing what they committed to do. But in any event, one question we can discuss is what were their lawyers thinking they needed to do in the way of maximally protecting the company? What inquiries about the administration's legal position did they ever make? The FOIA, the Freedom of Information Act request that yielded the Bondi letters was directed only to communications from the Department of Justice. They were not directed at communications that the Department of Justice may have received from the companies. And the companies have just simply either declined to engage with any questions about this or have outright, in Google's case, refused to answer those questions. So that's the thrust of the post, that this is really a deeply troubling situation and hopefully doesn't augur for corporate responsibility in this period of executive lawlessness in the future.
So, what you say the companies are not doing what they committed to do, and you mean comply with the law and comply with ordinary business ethics?
That's
Is that
correct.
right?
Both two things. One, comply with the law. And secondly, in circumstances like this, the degree of transparency they owe the public at large. So they're taking an action that is plainly in absolute defiance of the law, in reliance on representations made by the executive that themselves do not have a legal underpinning, and they are not transparent about the rationale that they're relying on here or the responsibility they're taking for this action.
Let's imagine that we're the general counsel of one of these companies. How does a general counsel think about that? Because um, my view is, and we can explore this a little later, but my view is that there's no plausible private or public liability that the companies face here. I don't think a private party can sue, a private party with standing can sue. I don't believe there's a private cause of action to sue. The government has proclaimed that it finds the law. It suggested it found the law illegal with regard to the president. That's why the president's not enforcing it, and the Justice Department has absolved the companies of any legal liability forever. So, if you're a general, and you're suggesting that despite those representations, that the general counsel of Google or Amazon or whatever should have advised the CEO, should have advised the company that they needed to shut the TikTok down.
The decision of whether to shut TikTok down is, of course, one that rests with the company board of
Right.
directors
So
and
I'm sorry.
officers.
Let me restate. Should
Yes.
have advised the company that it would be illegal to not shut down TikTok.
That's correct. I think that's in fact what most likely happened. I can't imagine a general counsel in written or oral communications to the officers and to the board in any way suggesting that it is a lawful arrangement with this administration to disregard the statute, that they can rely on the legal position that the administration has taken, reflected primarily in the Bondi letters. I mean, at a minimum, they owe candor to the board about what the law is and about the lawfulness of what the administration is doing here. Uh, the one question that I have then is what is, if you will, due legal diligence in these circumstances? So, one question I raise in the article is did the companies even bother, by some communication with the administration, to determine whether the question had been referred to the Office of Legal Counsel? Was there anything more behind the letters that Bondi issued, in which she makes sweeping claims? And by the way, the letters don't even cohere as a legal defense. They don't really make a whole lot of sense. But having said that, what more did, if you will, let me put it this way, in the way of a record of due diligence, did any of these companies attempt to establish, or did they enter just simply into a bargain, a sort of realpolitik with the administration? They could do it without any concern that they would incur legal liability in this administration, and they are banking on not having to suffer at the hands of a different administration in the future.
So I want to get to the different administration in the future in a second, but why do you think it's relevant whether they asked the Justice Department, whether the Office of Legal Counsel opined on this? I mean, this is a conclusion by the Attorney General. Whether OLC opined on it or not is irrelevant if this is a legal conclusion that the Attorney General has made. You might think, in a normal administration, you might think that OLC has some sort of dim quasi independence and would have offered a professional legal judgment. There's no reason to think that is true, and that it's offering an independent voice in this administration for reasons we've discussed. So why would that set of queries matter? Why would that be something that a general counsel should have asked about?
Let me refer again to these business ethical obligations that they have. If caring about compliance means anything, it means establishing a full record that the company explored the legal position that the administration was taking here and on which it is currently relying.
Yeah.
And the Bondi letters just don't cut it. I mean, nobody could answer a question from a board member. Do you find the Bondi letters persuasive? Do they represent a reasonable position on the legal issues in the case? And imagine the general counsel saying, yes, they're fine by me. And so then the question a board member might ask is, well, what more can we learn about the legal basis for the administration, which of course ultimately relates to what risks of liability the companies may be running? And as you suggest, we'll get back to the question of whether they actually are running, as a practical matter, any of those risks. But that sort of taking the law seriously, it seems to me, is something that for these major companies, frankly, you'd hope for any private concerns, would be reflected in the activities of the council in advising the board, and on the part of the board in pressing the council to fully understand what is at stake legally for the company. And there's no evidence of this. Now, it may be that that took place. We just don't know it. And the companies are really not speaking to the issue. I can certainly understand strategically why not. Google, as you noted, by the way, in a prior posting, and as I note in this one, has had to face a shareholder suit seeking board minutes and materials that may have revealed how the company discussed the legal issues here and the legal liability it faced. And the company, just to use the expression, told the shareholder to pound sand
Yep.
and declined to offer any answer unless compelled by court order.
One more quick question on this. I mean, isn't there a danger in asking the Attorney General what the legal base, what we know, who she consulted, and what the whether there's really a legal analysis here? First of all, I think there's zero chance that an Attorney General would answer that question. So maybe it would be good to ask just in terms of due diligence, if you get an answer saying, sorry, can't tell you. But what if you get an answer saying, there's no legal analysis. This is just my legal conclusion. I did it in my office one night. That makes it harder for what you're trying to do here. If
I
you're
don't
the
know that it does. I think
explain
that
why.
well, for two reasons. First of all, as you point out, you've asked the question. And secondly, all the Attorney General has told you is that the source of law that you're looking to find out about is reflected in her letters, and that's what you should be looking to. There's nothing else there. But you've asked the question, and when a board member says, are the Bondi letters satisfactory? And the answer is, of course, not. And then the board asks, is there anything more? Then the answer is no, and we've asked. And to me, that's due diligence. This is what we're dealing with. We're dealing with the Bondi letters and the legal position laid out in the Bondi letters, and there's nothing else behind them.
So I imagine the general counsel writing a two-part memo. Part one, we have a clear legal duty to comply under this law. Part two, there is zero chance of enforcement of this law against us by this administration, by a private party now, or by any future administration. And I think that maybe zero chances about a future administration prosecuting is a little aggressive, but not much. I think that there's practically no chance that a future administration, I mean, assuming that there's space in statute of limitations, that his future administration would prosecute under this law, and it provides for attorney general enforcement. The law does that a future administration would go after these companies for non-compliance with the law in light of the Bondi representation. And I think this because of the doctrine of entrapment by estoppel, which basically says it's a due process violation for in this context for DOJ to prosecute someone for something that it told, even in a prior administration, told an entity was lawful, that it would be a due process violation. Now, there are the application of the entrapment by estoppel to the Justice Department is very uncertain. I just want to read what Michael Dreeben, the person representing the special counsel in Trump versus United States in the oral argument and on the brief, said about entrapment of estoppel, excuse me, entrapment by estoppel at the Trump versus U.S. Oral argument. He says it would be a due process problem. He was talking about prosecuting a president, but just translate that to prosecuting one of the companies. It would be a due process problem to prosecute a president who received advice from the attorney general that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation. And so basically, he's saying for to be able to overcome entrapment by estoppel, there has to be like a criminal conspiracy between the attorney general and the person that she is advising. I don't think that this rises to that level. So tell me why I'm wrong to think that there's zero chance that a future administration prosecutes here.
Well, let me say, first of all, something about the background of Rieben's exchange in the immunity case. It's really quite striking. It shows you how the world that we live in has changed so dramatically. He's discussing the legal advisory structure in the administration as a critical safeguard
Yeah.
against presidential misconduct, and of course, arguing against the blanket immunity for former presidential misconduct that was at issue in the case. And he talks at length about how things normally work. The Attorney General and the Department of Justice take the law seriously. They're conscientious in examining the legal issues that the president puts before them. And even though Justice Alito, in particular, as I recall, expressed some skepticism about always the entire independence and professional conscientiousness of attorneys general over time, that's the background assumption in Dreeben's case. And it simply doesn't apply at the time in this
It doesn't
administration.
apply. I'll accept that for purposes of this argument, but is that going to be legally relevant?
Well, this is the what I'm driving at. What would it mean to say that there is a due process defense? I mean, a legal defense, not a practical defense. Let's go on and talk in a moment about the practical defense, but let's start with a legal defense against another administration proceeding in the face of Bondi's letters to prosecute. What is the legal limiting principle there? If the position that an administration takes is so outrageous, it is so clearly illegal, and the companies know it, and let's put it this way, dispassionate observers across the entire legal spectrum know it. That's really going to be a defense when the company knows perfectly well whether it's an actual or affirmative conspiracy or collusion with the administration or not. It knows perfectly well that what it's doing is illegal. That means that nonetheless, they're immunized from future prosecution by another administration. I find that really astonishing, actually. So imagine, for example, and now I'm going to take this a little bit into sci-fi world, so bear with me. I'm not going to defend the realism. I hope I'm not going to have to defend the realism of this hypothetical. Let's assume that a company engages in basically completely illegal conduct to destroy a competitor, hacking, breaking and entering, violation of non-compete clauses, whatever it is. And somehow, with respect to any federal issues that are implicated, it seeks from the Attorney General of the United States an opinion that, in fact, there are no legal consequences to these behaviors. And it then proudly presents this record to the next administration and announces that it has a complete legal defense, a due process defense. How can that be? How can that possibly be?
Yeah, so fair. And again, we don't know the contours of entrapment by estoppel. And that the Dreeben statement was maybe a little bit aggressive in describing entrapment by estoppel. But for me, it's not the legal defense to a prosecution that would preclude DOJ from a later DOJ from successfully prosecuting Google. I think there is practically zero chance that a subsequent Justice Department, let's say of an AOC administration or some future Democratic administration, I think there's zero chance that they prosecute here because that would be breaching a hugely important norm, and I'm using that word advisedly, that Justice Departments across administrations rely on, namely that their own legal opinions can be relied upon when they say we're not going to prosecute here for various things. Uh, they want those representations to be relied on, and if it would be as much of a norm breach as this is, and it really is, it would be a massive norm breach to prosecute someone that relied on a clear Justice Department representation. And I don't think it's the law that will prevent it from happening, but the institutional self-interest of the future Justice Department.
Maybe, although, we've seen that the norms that have typically governed the relationship of the president, the attorney general, or to the Department of Justice, those norms have really, frayed if they're intact at all. So what to say about how somebody views those norms in the future and the extent to which they view them to be binding, to me is kind of uncertain. I will say that, and this is the background of all of this, the largest reason that a future administration won't do it is that, in simple terms, people like TikTok. I mean, one of the guarantees that all of this, that this particular legal scam will succeed, is that this is a massively popular social media platform.
Right.
And a future administration will probably be more swayed by that than by any frustration over the lawlessness of the administration. But let me just take the question of legal liability into some other directions. But an administration declined to prosecute, but, and particularly if it had at least one House of Congress in its camp, how would I put it? Hold the companies to uncomfortable account for what they've done, conduct a hearing, write
Oh yeah.
letters.
Oh yeah, yeah.
Yeah, they could.
Yeah. No, I agree with everything you just said. First thing, I completely agree that the popularity is a hugely important factor here. My son asked me last night whether I thought TikTok was going to continue for a while, and I said I think so, for a long time. But it's the combination of the massive popularity of TikTok, at least for now. I mean, it used to be very, very unpopular on Capitol Hill recently, but
Yes.
the massive popularity of TikTok, plus what I do think is legal uncertainty about entrapment by estoppel, about the contours of that, plus the institutional self-interest point I made, which has some bite, I think. I think those three factors make it practically very unlikely. And so that's just where I land. And I just wonder, though, if you're the general, do you actually write? This is my last question. Do you actually write a memo like that? And does a CEO actually say, okay, i.e., a memo that says what we're doing is clearly unlawful, but there is zero chance that we're ever going to face legal liability for it? And on that basis, what is a CEO supposed to do? I mean, and let me just say, You just said that TikTok was very popular.
Yes.
So is Apple supposed to take it off uh, of its um, of its app page because
So
because it's clearly illegal, even though it faces no liability? Is that what you think should happen here?
what I think should happen is the companies should be accountable, accepting that businesses are businesses, and there's something more than even the popularity, although it's related to the popularity of TikTok, and that is the huge competitive disadvantage that companies will experience if they comply with the law high-mindedly and their competitors happily steal off into the night and do exactly the opposite. And that's going to be, of course, a decision that a business is going to be extremely reluctant to make when the revenues involved here are so substantial and the popularity of the product is what it is. As to the writing question, I think more likely, and again, I can't speak to the practices in every company, but more likely, this is a conversation, as I think the shareholder who filed that lawsuit seeking board minutes and materials understood, is going to be reflected in oral exchanges uh, between the council and the company, between the council, the board, and the officers. So I don't know that there'll be a 50-page memo saying, yes, we're violating the law.
Yeah, yeah,
And in fact, there may even be some directed by the general counsel to their own lawyers to put the best possible face on it to try to shore up the very poor argument that Bondi made.
yeah.
So I think that's most likely and more prudently what would happen
Right,
here.
right.
But let me just stress, I totally agree that we shouldn't be naive about this. We understand why the companies are doing this. I don't want to pretend otherwise. But there's a distance between the way they're handling this, which is to just go ahead and agree to participate in this lawless scheme, and their utter and total lack of accountability for it, including their refusal, for example, in the Google case, to even provide responsive materials, I think, in response to a completely legitimate shareholder inquiry.
That's a great place to stop. Thanks so much.
Thank you very much.